Hello and welcome to the first of FPF's launch of our privacy legislation series. We're really excited to be launching this series, which will cover an array of educational webinars exploring topics in US privacy legislation. In each webinar, experts will deep dive into one aspect of a comprehensive privacy law, discuss what makes it important for addressing privacy harms, its historical context, and how it has been addressed in other existing federal, state, or international laws. Each session will be made available publicly and provide a list of additional recommended readings and resources with the goal of providing policy experts with more tools to be better informed on data privacy legislation in 2020. We are not calling for or against any specific policies in these sessions. Our goal is to provide a wide range of objective resources and to give people who are new to this subject a sense of the full landscape. In this session, myself and Kelsey, my colleague Kelsey Finch, will be discussing, we'll be exploring covered data or personal information. So we will be exploring how it's currently defined, definitions, how definitions affect household information, device data, probabilistic identification, de-identified, pseudonymous, aggregated and inferred information, re-identification and the evolving nature of personal information in light of technological and commercial developments. A bit of a mouthful, but we will demystify these for you, I promise. So without further ado, let me begin. So here's just a little breakdown of who's going to be saying what. I'll be bringing us into the session by talking about the material scope of comprehensive privacy law, which is identifiable data. The rise of the concept of personal information in US privacy law, legislative approaches to defining covered data, and how covered data has been defined in recent privacy proposals. Kelsey Finch is then going to take over with defining data that's outside of scope, pseudonymization and less readily identifiable data, privacy enhancing technologies, and how identifiability impacts the law, as well as examples of evolving technology. So, most privacy laws in the United States are sectoral. For example, we have HIPAA governing the healthcare industry and the GLBA governing financial records. In comparison, in recent years, there's been a growing consensus that the US needs comprehensive privacy law to align with international norms and to fill gaps in existing privacy protections. To begin thinking about any comprehensive baseline privacy law, you first have to define what it applies to. Information privacy law can be scoped in various ways. Personal scope defines who the law is seeking to protect. Jurisdictional scope defines which entities the law applies to. However, today we'll be talking about the material scope. This is what this law actually seeks to regulate, or in other words, the object of privacy legislation. So what is the object of privacy legislation? Well, broadly, the object of privacy legislation is information. However, privacy law does not seek to regulate all information. Instead, the information that is relevant is information that relates to people. There are clear-cut cases of covered information, for instance, names and addresses. There are also clear-cut cases which fall outside of the scope. So, for instance, we're not usually concerned with data that comes from sensors of a factory or a jet engine. Although it's clear that data collected from sensors on a jet engine or a factory is not within scope, today we live in a world where most people have a lot of devices connected to the internet. So there's a lot of in-between cases. For instance, IP addresses, online identifiers, cross-device identifiers, and new types of identifiers are cropping up all the time and are set to continue with advances in technology and computing, storage, and machine learning. You've probably seen these terms before on the screen. Within the brackets exist types of data that we probably care about. These are the subject of ongoing debate in terms of what they mean. We will touch more on this later. The infographic on the right is recently published from FPF, which Kelsey will talk more about. So beginning with a brief history of how this concept of personal information arose in the United States, Think back to before the computer. To link information to a person, one may typically need a person's name or likeness. Or in other words, there were narrow linking attributes. People could often only be searched using a single index. The computer revolutionized search and organization functions, vastly improving our abilities to investigate, analyze, and manipulate data sets to find new ways to locate and identify specific persons. It became possible to ID people without information such as name or likeness, as searches could be made according to multiple attributes. The scope of information requiring privacy protection became larger, less clear, and more contestable, and the line between covered data and non-covered data became less certain. This can be seen reflected in policy and legislative responses from the 1970s onwards, with the rise of the concept of personally identifiable information. Because of these changes, we saw the publication in 1973 of the Fair Information Principles. They represent the first comprehensive articulation of privacy principles concerned with automated record keeping. They set the stage for all future privacy regulation, and we still look to them to guide us. For instance, one of the principles is against secret recording systems. They were very influential. They are very influential. You can see this reflected in GDPR and other laws internationally and within the United States. And as such, the US is a leading and incredibly influential player in privacy till this day. The Cable Act of 1984 represents a key shift in legislative strategy. Previous acts could take for granted what personal information was. There was less ambiguity. And they were concerned with different assemblements of records as the key jurisdictional trigger and key concept for the applicability of the law. Rather than regulating around how data is organized, the Cable Act approach was to regulate around information itself. This forms the building block for modern information privacy law. Cable would permit a user not only to receive information as broadcast TV did, but also to respond to information on the screen and to make programming choices. By collecting those data, the cable operator would be able to construct detailed profiles about viewing choices. This two-way communication, which enables vast personal data collection, is comparable to the modern internet. After the internet went mainstream, there was a further explosion of information created about devices and networks. However, despite the importance of personal information as a concept in privacy law, there is no settled definition, and to this day continues to evolve as a matter of law, policy, and technology. Various definitions have arisen in privacy law. So when I was going through researching all of the various privacy laws in the US, there are so many different definitions and so many different approaches. And so in order to find some kind of organizing principles, I've identified grouping principles and approaches. So first up, the tautological approach. Under this concept, by defining covered data simply as information which identifies a person, a legislative drafter can defer to regulators and courts. So this is a standards-based approach. Like other standards-based approaches, this is open rather than closed in nature. And as a standard, it can evolve and remain flexible in response to new developments. However, on the other hand, by defining personal information as any information that identifies a person, this approach fails to actually define personal information or explain how it is to be singled out. So at its core, this approach simply states that personal information is personal information. And as such, this definition is unhelpful in distinguishing personal information from non-personal information. So the specific types approach is, on the other hand, a rules-based approach. So you can list specific types of information that constitute personal information within the legislative language. If information falls within this category, it becomes personal operation by operation of the statute. There's a risk that this approach can be restrictive, but there's also a risk that it can become quickly outdated. So it's generally much better to have a non-exhaustive list and to defer rulemaking authority to the FTC, as can be seen here with COPPA to an extent. It's a certain twist on the specific types approach. So moving on to the next slide. In addition to varying legislative approaches, much of US privacy law is enforced by the Federal Trade Commission, the US's Consumer Protection Agency. The FTC's jurisdiction is limited to unfair and deceptive practices, which means that largely companies must abide by however they describe data processing in their privacy policies. Nonetheless, the FTC has influential views about what personal information is and de-identification, and these views have been very influential in shaping US business practices. These definitions come from staff reports, public statements, and my colleague Kelsey will discuss this further in her portion of the presentation. So a third approach to approaching the issue of defining covered data for the purposes of a comprehensive privacy law is the expansive approach taken by the EU. So this approach is to define, cast a wide net and define personal information really broadly. If you take this approach, then it's necessary to make provisions which allow for guidance and for businesses to comply with the law. For instance, if it's not very clear what is identifiability. So there needs to be room for guidance with an approach like this. So this really is the traditional approach in the EU, and quite frankly, it's more in tune with technological development. Notably, many US companies are currently complying with the GDPR, either to operate in the EU or as a matter of principle. Lots of companies in the US really depend on the trust and support of their customers, and their customers demand equivalent privacy protections to US citizens. So moving on now to federal proposals and discussion drafts. This slide really is just to show you guys that there is so much happening at the federal level. There's a lot being discussed right now. These are all bills that have been proposed and are moving through Congress, some more successfully than others. But safe to say, there's a lot going on at the federal level. And so that also means that there's a lot going on in terms of how personal information and how covered data is being defined. It's very difficult to define covered data, and these recent federal bills demonstrate how people have been trying to approach it recently. So this is some language that I've taken from each of the bills, and there are a few things to note about the approaches taken. The first thing to note is that most bills' definition of covered data are almost identical and broadly follow the same structure outlined in this slide. So to summarize, most bills cast a very wide net for covered data. This can be compared to the wide approach taken to the GDPR, which we've just touched upon. Like, the concept of singling out is not something we've historically seen in US law. It's an interesting trend to take into account this broader set of concerns. It can be compared and contrasted with a more reductionist US approach that has been taken in the past. So it's a really interesting break from tradition, and it really shows that there's been a real shift in thinking about privacy in the US as of late. Specific language that I would really like to draw attention to from these bills is the use of the language of reasonableness, linkability, and the inclusion of identification not only of persons, but in most cases also of devices, households, identifiers. Lots of recent bills also include within the scope of information inferences, aggregated information, and pseudonymized information, and provide definitions for identified and identifiable information. Some bills also separately define sensitive personal information, usually taking the specific list approach here, as already described. Or in the case of the Del Bene bill, it only defines sensitive information. So that's an interesting twist. Of approaches taken at the federal level at the moment. So by creating these various subcategories of personal information that I've just described, it seems that these bills are recognizing that identifiability rests on a scale, and they're making attempts to differentiate and prioritize regulation according to risk of privacy harm, information sensitivity, context, and user expectations. Kelsey will talk more about the significance of nuanced identification and de-identification standards after I finish my portion of the presentation. Just to repeat what I've said, the reason for the width of these definitions is that we've seen a clear shift in norms of understanding privacy in the last few years in the United States. And, you know, this is really because this can really be exemplified by this quote by the FTC in 2010, which really shows that the FTC recognizes the blurring of the distinction between personal information and supposedly anonymous and de-identified data. Identifiability is a complex concept because of the changing landscape of technology, as well as social and corporate practices. Many tools now exist for retrieving de-identified information, analyzing it, and linking it to other information in order to repersonalize it. Due to ongoing technological developments, the concept of personal information is not fixed, it's malleable in nature. So increasingly, various pieces of non-personal information may be combined to create personal information by overlapping databases and to form links between some data and a specific person. So new and surprising discoveries are constantly being made about the ways of combining data to reveal other data. So for instance, a person's social security number can be predicted based on other pieces of data such as birth date and birth location. Indeed, it's possible to predict entirely from public data narrow ranges of variables wherein individual social security numbers are likely to fall. When I heard about that, I was pretty shocked. So there's a proliferation of personal information in online and offline record systems. As additional pieces of identified data become available through more and more sources, including, for example, through the rise of the Internet of Things, connected cars, smart cities, it becomes easier and easier to link data to people. So, my key takeaways. Law must keep up with technological developments. There are a multitude of ways that a legislative drafter may wish to take, alone or in combination, to address the wide array of information which relates to and implicates people in the information age. To reiterate my opening remarks, there is some information which is clearly personal, for instance, names, address, social security number. However, there's also a gray area and borderline cases. As such, a flexible and multifaceted rules-based approach and standards-based approach combined may be warranted, which takes into account, along with risk of identifiability, also context, user expectations, information sensitivity, and risk of privacy harm. So flexibility. This really is inspired by the tautological approach taken by some US privacy laws that I explored earlier. So inspired by this approach, policymakers may wish to avoid being overly prescriptive in their definition of covered data and use language such as reasonableness. You can see some of this appearing at the federal level in draft proposals to an extent. You can see this flare. This would allow the law to be more responsive to technology, as the definition could arise naturally over time in the courts and through guidance. The ability to distinguish between personal information and non-personal information is frequently contextual. Many kinds of information are not inherently non-identifiable or identifiable as an abstract matter. Due to the complex nature of what is personal information, sometimes abstract definitions are not appropriate. So for instance, taking search engine results as an example, you can't determine in an abstract way that search engine results are not personal information. I mean, it depends on the nature of the search. For instance, a lot of people are guilty of making vanity searches in which they type their own name, and this would clearly fall into the bucket of personal information. So for all of these contextual cases, it's important to allow judges to conduct fact-intensive inquiries where possible. So secondly, tech neutrality. Linked and overlapping with the flexibleness approach, the law should not be too prescriptive or restrictive in terms of technology if it's to avoid becoming quickly outdated given the quickly evolving technological landscape. Width. The law must be drafted widely enough to be inclusive of the wide array of information that may be related to individuals, i.e. by including information related to devices, households, and other identifiers. This approach is reflected in current and proposed laws. The law must be nuanced. Recognizing that identifiability rests on a scale, the law should be nuanced enough to A, tame the inbuilt flexibility of the law, and B, if covered data is drafted widely, then it's sensible to categorize it in certain ways to break it down. So the binary personal and non-personal distinctions, which were logical in the 1970s, are outdated in the information age. As a start, legislative drafters may separately define a number of terms such as identified, identifiable, pseudonymized, aggregated, de-identified, anonymous, inferential, and sensitive information, as have been proposed in a lot of recent proposals, as well as already ingrained in existing law. So yeah, many laws internationally and in the US have already begun to take this approach, and it's also by defining these terms, legislative drafters can then open the doors to create a nuanced set of exceptions and variable standards for de-identification and the such like. Kelsey will go into more detail about the significance of de-identification standards. A twist on the specific types approach. So another way to counter the expansiveness of casting a wide net for the material scope is to include an open list of specific examples of the types of personal data that the legislative drafter may have in mind at the time of drafting legislation. So for example, information such as, but not limited to, X, Y, and Z. This approach can be seen in various federal proposals. And another twist on the specific types approach, which can be seen in various laws and proposals, is the inclusion of a separate subcategory of personal information, such as sensitive personal information, where drafters can list certain types of data that they feel warrant heightened protections due to a clear risk of substantial privacy harm. So for instance, geolocation, biometric information, and children's data. This can also take inspiration from existing laws and proposals. And finally, just to reiterate, it's really important to leave room in your definition for it to be modified over time. To ensure alignment with new technologies and business practices, an administrative mechanism may be contemplated to update, revise, or supplement the definition of covered data. So room must be left for guidance. There's a lot of incoming guidance coming through from the UK and the US at the moment on anonymization, and room must also be left for rulemaking authority. So the Rubio bill and the Intel bill both do provide for this in various ways, which is an interesting take. So to summarize, PII is a challenging conceptual issue at the heart of any system of regulating privacy in the information age. If personal information is defined too narrowly, then it will fail to protect privacy in light of modern technologies involving data mining and behavioral marketing. Technology will thus make privacy law irrelevant and obsolete. On the other hand, if personal information is defined too broadly, then it could encompass too much information and threaten to transform privacy law into a cumbersome and unworkable regulation of almost all information. Privacy law must have coherent boundaries which adequately protect privacy and which can be flexible and evolving. So I'm about to hand over to Kelsey, who's going to talk you through the data that is not covered. So I've just finished speaking about data that's in scope for legislation, and Kelsey's going to now speak on the other side of the coin about de-identified and anonymous data. So what is considered out of scope and is often as important as what is explicitly within the law's jurisdiction. So first, I want to be clear that what it means for data to be de-identified can be a legal question, a technical question, or both, depending on who you ask and what situation you're in. And that's why it's important that we think about the identifiability of data on a spectrum. On the one end, we have information that's explicitly personal.
And that, can pose a great risk to an individual if it's inappropriately used or shared. Things, names and social security numbers, where there's really a one-to-one connection, and it doesn't really take much effort to find the specific person at the end of a piece of a data record or piece of information, or to influence their behavior in some special way. And then on the other end of the spectrum, sort of as far down as we can go, we have sort of highly aggregated or anonymous information, that poses almost no risk to an individual. And so we say almost no risk because I don't believe that we live in a perfect world. Things can always happen, but it's about as low as we can reasonably get. In an imperfect world. And so these are things like statistical information. So knowing the number of women aged 25 to 35 in Washington, D.C. Can give you a little bit of information if you know that I am a person who lives in D.C., but probably not something sensitive, probably not something that rises to the level of, the full panoply of privacy restrictions. And so, generally speaking, as the way that we think about it here at FPF is that the more identifiable the information is, so the more in this green area, the more privacy risk it's going to tend to create. And the greater that risk, the greater the need for regulatory safeguards. When there is very little or no risk, you might not even need to apply any privacy rules, although different jurisdictions are drawing that line differently. These laws are trying to incentivize organizations to process their data so that it's as far into those sort of blue or purple categories, the de-identified or the anonymous side of the spectrum as possible, and recognizing that, some flexibility along the way can be really important. And Paul, if you wouldn't mind advancing to the next slide. So the reason that this flexibility is important is because the promise of de-identification is that we can protect privacy and still gain really valuable insights from the wealth of personal data that's being created today. The problem, unfortunately, is that there is an inherent and somewhat unavoidable conflict between how useful or how precise the data are and then how private they are. So the way that de-identification works, put simply, is that an organization will take a data set that contains personal information and remove or change or manipulate those pieces of information that could be linked to a specific person. And then, of course, every time that you are eliminating a data field or you're introducing a noise or a new random value, you're protecting privacy, but you're also making that data less reliable and less accurate, and therefore you're lowering its analytic value. So as you can sort of see in this slide, the ideal, in an ideal situation, we'd be able to achieve maximum privacy and maximum utility. But in reality, we need to figure out where the acceptable trade-offs are going to be. And I think this is an important piece for legal standards. They help us understand, sort of as a matter of public policy, what we think the appropriate trade-offs are going to be in a variety of contexts. So, clear legislative language and detailed regulatory guidance are really key tools in helping organizations determine what is an appropriate level of de-identification given a particular situation and use case. And so, Polly, the next slide would be great. And, just some core concepts when folks are thinking about drafting definitions of de-identified data, really important things to think about is what are you trying to protect? There's a bunch of advancements in the disclosure control literature, the sort of science of re-identification. And so it's important that policymakers and organizations who are putting into place these kinds of safeguards are thinking through very specifically which aspects are the most important to them. So, questions to ask are, which kind of disclosure risk are you trying to protect people from? Thinking through whether or not the concern that you have is if you can identify a person, if you can take, some record and then put a name to it and know that this is Kelsey Finch's healthcare information or purchasing patterns or things like that. That's one set of harms that we've traditionally been very concerned about in the US. Thinking about contactability, does it matter whether or not you're able to reach out and contact or touch the person? It's a slight variation on the identifiability. Thinking through singling out or sort of being able to understand attributes about a person that you might not have known before, even if you don't know what that person's name is. All of these things are different things that the literature, the sort of re-identification tools and the de-identification tools on the other end can be used for, but you need to be specific. And the concern that if folks are drafting too broadly or too narrowly, they're going to miss out on the set of safeguards that they're really hoping, and they're going to sort of leave open some of these loopholes. Also important is to think about sort of who is the attacker. So de-identification specialists use the word attacker in the same way that data scientists use the word attacker, just as somebody who has a motivation to try to understand and sort of re-identify a person in a purportedly obscure data set. So, you know, and again, there's a variety of options. You need to understand if you're really concerned about experts who are, you know, on the cutting edge of the science, have a lot of resources, and really understand as a technical measure what's possible with new computing power and algorithms and sort of new mathematical and statistical tools. But maybe you're concerned about ordinary people. Maybe you're concerned about, you know, nosy neighbors who might have some insider knowledge that will allow them to, you know, look at a, you know, a data set of people who, you know, like 911 record calls or things like that, and say, oh, I know that person, that's my neighbor. Or see, you know, a database of voting records or health information and recognize maybe somebody in their own family, maybe recognize themselves. You know, sort of thinking through, are you worried about folks who are going to stop at the, you know, the legal limits, in which case you can rely a little bit more on things like, you know, contractual controls and promises. But if you really don't trust that, you know, a contractual commitment not to re-identify is going to have much force, then you need to think about other kinds of potential, you know, motivated intruders. And I will flag that, of course, in practice, the folks who seem to be most likely to re-identify a data set tend to be grad students and computer science academics who are sort of advancing the state of the art in this space. So, you know, it's a variety of folks, you know, looking here. And yeah, I think seeing a great, you know, example here from Matthew in the comments that hospital workers looking at patients that they're not treating is a great example of thinking through the potential world of motivated intruders or, you know, quote unquote attackers. I think also really important to recognize the context. So one of the things that most of our laws have been silent on, unfortunately, is sort of what the confidence threshold should be, right? So if I can, you know, at a certain point, I can guess information about an individual, and I might have a 50-50 chance of being right. You know, it might be lower than that. So the question is, at what level of, you know, confidence should an attacker have to believe that, you know, to have accuracy in what they've learned about you? At what point should that trigger re-identification under the law? And that's very unclear. You know, the standards differ widely, and there's not a lot of specific guidance. We get the question a lot from folks in organizations about, you know, so if I can reduce the risk of re-identification to, you know, 2% or 0.2%, is that acceptable? And that's a really hard thing to think about. Really important for policymakers to have in their heads, though. You know, is it a more likely than not standard? Is it, you know, something higher than that? But thinking through some of those ramifications. Also important to recognize that the same data might be personal in one context, but de-identified in another, or even in the hands of another organization. So if I have collected a bunch of information and I want to de-identify it to use it for a research project, you know, within my own organization, you know, that might still be personal information. If I retain the original records and I retain the key that I used to do the de-identification, if, on the other hand, I share that information with an academic in a different institution who has no access to the underlying linking records, it might very well be considered de-identified in their hands. So needing to think about what happens when data moves from one organization to another, and the accessibility of tools for re-identification change. I think similarly, recognizing that increasingly data about one person might be data about other people. So if there's a shared device, you know, recognizing that folks might all hop onto the same Wi-Fi network at the Starbucks down the street, that you might be reflecting information about a household rather than a particular person, which is a consideration that we've seen recently reflected in the California Consumer Privacy Act. And then genetic information, which of course, as folks are using more and more consumer tools and consumer genetic testing, is having an impact for the entire family and genetic lines. And so that's a little bit on context attackers, disclosure risk. The other piece of this is that recognizing that de-identification isn't a silver bullet. It is particularly well suited for things like structured data, but we do not really have sort of scalable, really reliable, useful tools to attack every type of information. So, you know, things like precise geolocation, images, video, audio, you know, biometric and genetic information, as I mentioned. And then, you know, having to recognize that really the hard part of de-identification in practice is around outliers. And so needing to create incentives to ensure that, you know, organizations are thinking holistically about how they want to be doing de-identification is really important here. So Polly, if you wouldn't mind moving us to the next slide. Just really quickly, the next piece of this is to take all of those considerations and to give you guys a little bit of a sense of how this works in practice. Is that we have some traditional approaches to the technical measures of de-identification, so how it's accomplished. And then we also have some emerging technologies that are important for folks to think about and have in mind as we try to make sure that the law and the technology are moving forward, at least in some sync. So traditional methods for statistical disclosure control or disclosure avoidance, as you might see it referred to, are things that you might sort of intuitively think about if you're trying to make a data set less identifiable, right? Like you can suppress fields, you can just take out all the names. You can blur or generalize records. So maybe you take, a date of birth and you turn it into a year of birth, and that makes it less identifiable. Already, you might perturb the data by adding random noise so that each record is still statistically valid because you're using some sophisticated math, but that you are still, removing the accuracy of the underlying data and making it that much more difficult for any particular individual to be identified. Similarly, you can aggregate a bunch of records so that you're not sharing information on an individual record level, you're sharing it in a sufficiently large set that, similar to understanding population statistics about the, District of Columbia, it's really, really difficult in those situations to get back to a particular individual. And so, a bunch of these things have come together. Key anonymity is probably a term that you might hear for ways of adding random noise and sort of trying to find benchmarks for how many records should look similar before you consider them de-identified. And there's a wealth of science that I'm not going to get into there, but I think helpful terms to have in your mind. Also want to point out that in most situations, we try to pair these technical measures with legal and organizational contracts, right? That there are some folks who are skeptical about the value of contractual promises to not re-identify or to only use the data for certain purposes. But by and large, this is an effective, these are really effective safeguards to help buttress a de-identification approach. Assuming that most of the world is good actors, most folks are trying to do good and follow the law and be in compliance. And so, these are tools that we see and that we use all across, sort of privacy and are sort of at the heart of many of the FTC's consent decrees and other sorts of restrictions that we build into law. So, strongly recommend that folks use them where they can. So contracts, so particularly commitments not to attempt to re-identify and use limitations. Then also things like access and security controls to make sure that only employees with a need to know have access to it. So that folks are often worried about I think that great example of hospital employees looking at records for folks who aren't their patients, or marketing teams dipping their hands into research data sets or security information. And so making sure that you're really clearly segregating things out on sort of a need to know and a need to access basis. And then increasingly, we're starting to see folks also go through things like ethical and disclosure review boards. So if you're trying to make a decision about how to use de-identified data or whether to make de-identified data available to another organization or to the public, gathering together a body of experts to make that determination on a case-by-case basis. So those are sort of the existing suite of tools that we have. I'll flag that there are really exciting emerging technologies in differential privacy, secure multi-party computation, and synthetic data. And so I listed some of the federal agencies really working hard on making those more available at scale and more easy to use. We are still a bit of a ways from seeing those roll out in organizations large and small. We've seen some of the major tech companies, Google, Apple, Uber, others sort of dip their toes into differential privacy. US Census is going to be doing a really big project on differential privacy for 2020. But these are often not ready, I think, to be baked into legislation. Good to encourage, good to continue to try to foster research in these spaces, but not quite ready for prime time yet in many cases. So then moving on to the next slide. And because I got really excited about the technical things, I'm going to go a little quickly through the legal approaches. So I think two of the major ones that folks have in mind these days are the FTC's approach and the approach under the GDPR. And recognizing that the FTC is a little bit more risk-based, perhaps, than the GDPR and the guidance that we've gotten from the Article 29 Working Party, which provides guidance around interpretations of that. So under the FTC approach, we have sort of what we call informally the three-part test. It comes out of the great 2012 report on protecting consumer information in an era of rapid change. And it sort of says that you have to do three things to consider data to be not reasonably linked or de-identified. So you need to take reasonable technical steps to de-identify, given the context of the data set. You need to make a public commitment not to attempt to re-identify the data, and that's the jurisdictional hook for the FTC to bring a Section 5 action against you. So if you make that public commitment and then you violate it, then you can be on the hook for legal risk. And then you also have to make, anybody else that you share the data with must make a similar commitment not to attempt to re-identify the data. And then the FTC acknowledged that they talked to this confidence threshold, right? They said you must have a reasonable level of justified confidence in the de-identification techniques, that sort of this data is not reasonably linkable to a particular person or to a device that's associated with a person. And then they acknowledge that reasonable depends on the circumstances. So it's a flexible test here. So thinking through the available methods and technologies, the nature of the data, and how the data is going to be used among presumably other factors. The GDPR is a little bit more sweeping. So they think about anonymous data as information that does not relate to an individual or an identified or identifiable person. And they look at the all means reasonably likely to be used test. And important to note here that they think about all means reasonably likely to be used either by the controller, so the organization that is in charge of the information, or by another entity. So this is a different kind of standard than we see here in the US. And they explicitly take into account a wider range of disclosure risks than we typically have in the US, right? So the FTC test is very much about linkability, but Article 29 tells us that for the GDPR, we need to also ask, is it possible to single out an individual? Is it possible to link records? And can information be inferred from this information? All of these things together, put together, whether or not it can be reasonably likely to be re-identified. And again, taking into account cost and time, the available technologies today, but then also technological developments in the future. So the sort of traditional understanding of the GDPR approach is that it's a little bit closer to a zero risk, threshold, that they're really trying to make sure that folks are thinking and trying to future-proof these things as much as possible. Moving on to the next slide. Really quickly, just because these are some of the major de-identification standards in the US as well. HIPAA is, I think, the one that actually comes to mind first for most folks. I think, despite the fact that the FTC approach applies sort of to a broader set of organizations, the HIPAA privacy rule is sort of one of our very first bites of the apple in the US at trying to set these standards. And is a really interesting one because it's a little bit more prescriptive than we see in other spaces. The FTC has given you sort of a flexible reasonableness test, but HIPAA says, there's two specific methods. One of them is that you can hire an expert and they will do a very in-depth study and they will determine that if you have a very low risk of re-identification, that this is satisfactory, and it will be time bounded. So that expert can only look at the data, and make a determination that the risk of re-identification is very low for maybe 1 or 2 or a little bit more than that in years. There's not many folks that do this in the US, but it's a way to have a little bit more flexibility for people who have really sophisticated programs or are doing something particularly nuanced with their data. But for a lot of the world, what they rely on then is the other sort of option under HIPAA is the safe harbor, which is that they have provided guidance that there are 18 types of identifiers. There's really 17 types of identifiers and then one sort of catch-all category. And if you remove all of those, and then you have no actual knowledge that any remaining information in your data set can be used to identify an individual, you're free and clear. And you can consider this data de-identified and outside the scope of the law. So those are sort of, a very different approach. A lot of folks like, like having the clarity of that guidance. But on the other hand, thinking through how future-proof is this and how much flexibility was built in at the time and have things changed between now and when HIPAA was passed. FERPA similarly has a sort of different approach. They provide a lot of guidance and a lot of education around the identification for student records. but aren't as prescriptive. They just sort of provide helpful ideas of how to aggregate data in some situations, how to think about whether there's still a record, link attached to a particular information, and see things a little bit more on a spectrum from protected information to information that can be made public. And then down at the bottom, you can see a really great graphic that I have shamelessly stolen from the team at Privacy Analytics on some of the risk thresholds that we have seen start to emerge from practice in some of the federal agencies. So when we were talking about sort of, what's the quantitative risk of re-identification, we can see sort of everything from 0.5% to 0.05%. And thinking through the range of things that have emerged just from, making different contexts in different agencies. So I'm going to jump to the next slide. And this is going to be quickly the sort of the in-between for a lot of these things is pseudonymization. And this is actually where a lot of the fun conversations happen. But again, just to really flag for folks that pseudonymization is really hard to say, so people trip over it a bunch and don't feel bad. But one, it can refer to either a legal category of information that's identifiable but not identified, and it's a specific de-identification or anonymization technique. So you need to be really careful which you're talking about depending on context. And flagging here that in a lot of the new bills that Polly was talking about, device identifiers, probabilistic identifiers, are pseudonymous, and this is sort of where those are meeting. So things like IP addresses and cookies, and things that look, they can be tied to a particular individual in many cases with some level of confidence, but they don't have a name attached. They probably don't have contact information attached, and so that's where this tends to come up. In existing laws, both HIPAA and FERPA have had exemptions for pseudonymous data. And the reason for this is that, and this is sort of why companies pseudonymize data, is that you can better optimize the utility and privacy trade-off that we were talking about earlier. So a wider range of productive uses of data. So in the HIPAA context, if you do a limited data set, you have to commit to more privacy safeguards. You're still covered by the law now, and so you have to do data use agreements. And so you're not free to do anything you want with it. But in exchange, you can get things like date and time back, and you're allowed to use those to do analytics and research and other kinds of products that would otherwise require the full commitment of sort of the HIPAA privacy rule. And then so that's sort of the two legal approaches. And then as a technique, pseudonymization is sort of applying a pseudonym, right? So if you take the name Kelsey Finch and you replace it with a new code of some sort, that is less identifying, that's pseudonymizing as a technical matter. And so I think the challenges of pseudonymous data is that it can be a moving target because it is this gray zone category. As more information becomes available in the world, we realize that more and more things can be identifying or can be linked. So a great example of this is the Netflix study from a couple of years ago, where Netflix released a bunch of viewing pattern information, and then a set of computer scientists, and I believe they're still grad students at the time, took a whack at it and realized that they could correlate those viewing patterns and ratings with the information in the IMDb database, and they could find individuals, which is, of course, so it turns out that how you rate movies is identifying, which is probably not something that, organizations generally are taking into account when they're thinking through these things. And so we start to see more and more advances in computing power, in re-identification techniques, and in the availability of data. And so all of that is making, more and more things fall into this category of pseudonymous data. Recognizing also that you can create perverse re-identification requirements if laws are scoped too broadly. So, for example, if you're trying to enable consumers to make portability requests or access requests to their data, and the company has already made it pseudonymous, they've already moved it down that spectrum towards less identifiable information, which is generally good. And it sort of would make a strange situation to force them to re-identify it to enable that consumer request. So, thinking through those kinds of interesting intersections. And so again, thinking through mobile IDs, hash MAC addresses, things where we really don't want companies to try to tie them back to a name and an individual person just for the purposes of satisfying another part of the privacy law. And then, of course, these require a mix of technical and legal safeguards. And sort of the only final note on pseudonymous data is that it probably should never be made public. Many of the studies and sort of the famous news reports that I'm sure you've all seen about data that has been re-identified is because it was pseudonymous to begin with. So it was probably never properly de-identified. So jump into the next slide, just to really quickly make the point that de-identification is a lot of things. It is not a silver bullet. It is not one size fits all, and it's not a set it and forget it safeguard. Real resources and evaluation are frequently required. And so we need to think through in legislation, building incentives for companies to continue to do this hard work, because it's valuable when we do have de-identified data available for a wide range of purposes, including really valuable and socially beneficial research. And so sort of the counterpoint to that, de-identification is really useful as mitigating privacy risk in a variety of scenarios. It's useful for data sharing and is useful for data security. It's also a helpful way to do privacy by design and by default, right? Baking privacy safeguards into a particular product or service from the very beginning to ensure that sort of we've lowered the risk at every step of the process. So going to take all of that, and I'm going to try to quickly sum up some legislative takeaways in the next slide, Polly, if you wouldn't mind. And just to sum up all of the things that you've heard from Polly and me today, so just to highlight what we think are some of the key considerations for U.S. policymakers, at the state or the federal or even at the local level. Really important things here are interoperability with existing laws. So needing to understand that we are, this sort of shift that Polly was describing towards a broader set of definitions might make folks uncomfortable who are used to sort of a status quo where things like device identifiers and pseudonymous data, maybe wasn't specifically considered or explicitly considered personal information, but that to keep up with sort of international standards and sort of the changing pace of technology and consumer protection, we might need to be more explicit about the idea that these things will be considered personal information. Sort of the FTC has been making steps towards that through its COPPA rulemaking, through public statements, and sort of that's been the general trend in regulation, but it still comes as a surprise to folks, particularly in smaller companies who may still think about things like IP addresses as sort of, there's a tendency to look at things and say, there's not a name attached to it, I can't figure out who you are, it should be fine. And that, of course, is not always the case, and we'll need to do some work to try to ensure that we're setting clear standards across the board. Another key thing is keeping pace with evolving technology, and this might mean rulemaking or guidance authority. It's really, really difficult and probably not valuable to try to condense or try to capture a particular moment in time in the de-identification and space in legislation itself. I think the way that we've seen folks broadly defined, linked and identified and identifiable, linked directly and indirectly, all of these are great attempts at sort of finding that perfect fit between too broad and too narrow. But it's also helpful to have other mechanisms to relieve uncertainty so that people can comply and that folks aren't just guessing and crossing their fingers and hoping for the best. We also need to avoid inadvertent outcomes when we're drafting this kind of legislation. So as I was explaining with the pseudonymous information, not requiring re-identification to comply with other consumer requests. It doesn't often make sense to make data more identifiable in order to achieve privacy goals. It's also important that we don't criminalize legitimate research. So in the same way that we want to enable, sort of white hat hackers in a variety of security spaces, similarly with de-identification and re-identification research, we want to make sure that that's happening in legitimate spaces. We also need to resolve some legal tensions. Treat de-identification as a process and not an outcome, much in the same way that we treat data security as a process and not an outcome. We want to encourage folks to do the best they can and to put reasonable and appropriate safeguards in place, but we don't want to hold them accountable for, acts of God or truly unforeseeable, situations which can occur in both de-identification and data security. And, you know, we want to allow folks to have some flexibility in how they're responding to things like access and portability requests, depending on the identifiability and the risk of the data. So, you know, if information is very sensitive and it's not very easy to verify, we might not want companies, you know, responding to access requests without doing some sort of authentication. So we've seen this baked into the California Consumer Privacy Act and to other potential state bills where, you know, companies are allowed to require, you know, verified, you know, to verify users or to authenticate the users to make sure that they're giving that personal information to the person that it belongs to and not to somebody impersonating them. You know, I think thinking through, you know, you can pair that kind of flexibility with exemptions from certain requirements. You know, for example, if you're going to use pseudonymized data for research purposes, maybe deletion or a purpose limitation doesn't make as much sense. But then you need to complement it with other kinds of safeguards. So, you know, approval by an independent ethical review board or something like that. And then, which is just to say that in all of these cases, the way that we like to think about the FIPS, the Fair Information Practice Principles that Polly was talking about and guide so much of these things, is that, you know, you can trade off between them. In some cases, if access or the individual rights, you know, need some flexibility, you can strengthen them by leaning on collection or use limitations or data minimization principles to sort of rebalance the privacy protections there. And then finally, just calling that there's a lot of important research still to be done on privacy enhancing technologies like differential privacy and secure multi-party computation, on-device processing. And then all of these things would benefit from further federal study and resources and investigation. So those are sort of our broad takeaways, things that can be captured in the law, things that can be captured or sort of promoted through the law. And I really hope, you know, I think that folks can learn from this. I think, Polly, if you wouldn't mind going to the next slide, we have some resources that we wanted to highlight for folks. Following this, I think, of course, we'll make the slides available. And I think we have about 5 minutes for Q&A. Apologies for running a little bit long on my section. But, you know, Polly, let me know. We might be available to stick around for a little bit and answer some questions as well. But for folks who are at the top of the hour and need to hop off, we really appreciate you joining and encourage you to come back for future sessions. But so for now, let me see. I see one question.
Hi.
Oh, hey, Polly.
I've got some questions here listed from listeners. So they all refer to you, Kelsey. So I'll just ask them, and then if you answer. So
Sure.
First off, how would companies gathering / accumulating consumer data fall under the expert type of attackers?
Yeah, well, so that's a great question. And some of this comes down to, you know, in the same way that some of the potential attackers are things like data brokers. And so it's not a, you know, a strict persona, but if companies have the resources to re-identify information, you know, to combine records or to purchase a data set from somewhere or to have a partnership agreement and, you know, be able to do that matching, they could very well be considered the kinds of entities that you're trying to protect against, right? That you want companies to not be able to secretly learn new things about their customers, maybe without some sort of notice or some ability for consumers to understand what's happening. And so I think, you know, it's interesting because when I say expert in a lot of the sort of scientific literature is really thinking through, you know, independent researchers and people who are trying to, you know, live and breathe the identification. They don't think about folks with other business motives, but that could certainly be part of the considerations that you're taking into account, right? What would an ordinary business, you know, have available to them, or what would a business in, you know, a particular line of work be motivated to do? What kinds of resources would they have to access information that could link to other records? To get access to the computing power and the re-identification techniques to actually do the combination. So both very, I think, very relevant in thinking through the list of potential quote unquote attackers.
All right. So another question, what's the difference between perturbation and differential privacy?
Oh, that's a great question. So strictly speaking, there's a whole world of differential privacy information that I encourage folks to dig into. It's a little bit scary because there's math on a lot of the pages, but actually, if you're looking at the recommended readings, this primer on differential privacy for non-technical audiences is a really, really valuable resource, and really encourage folks to look at it. But the quick answer is that differential privacy is actually a measure of privacy. It's not itself a technique, which is interesting. It's a mathematical guarantee that if you're using a differentially private solution, that you will not be able to know the analytics of the data set should be the same whether or not one particular individual's data is present or not. So then you can measure the impact on that person's privacy in a very quantitative way. And the way that they achieve this is through injecting noise, right? Random noise that they know, and they know, and then they can do the statistical, analysis based on. But injecting that noise is the act of perturbation. So if you do it in a way that fulfills the mathematical requirements of differential privacy, it's differential privacy. But if you've done it in a different way, if you're aiming for k-anonymity or something else like that, it will just fall under a different name. So hopefully that makes sense.
Okay, and on the slide that says pseudonymization can refer to a legal category of identifiable or but not identified data, please provide an example of this, if possible.
Yeah, sure. So I think a good example of this is a MAC address. So a identifier, or a device identifier of some sort. So my phone, as I'm walking through the world, is emitting signals, trying to connect me to Wi-Fi networks or Bluetooth signals. And those are unique to my phone, so that I can make that connection, sort of a function of how the technology works. And it might rotate, it might do any number of things, but for a moment in time, that device identifier is related to me. But it would take a lot of work to figure out my name, Kelsey Finch, attached to, this string of alphanumeric digits. Or, like an IP address, or if you hash an email, so that you've transformed it into some uninterpretable, list of numbers and alphanumeric, features that you can't directly identify me from it. You can't just casually glance at it and make that one-to-one connection to a person. But you can probably use it, and if you can find that same, piece of information, that same code replicated in other data sets, you could learn about me over time, perhaps, or you could link me to other records. So hopefully that answers the question.
We've had a number of people asking about the best places to learn about different new types of de-identification, like multi-party computing and differential privacy. I know you've already provided a couple of examples, but if you have any others, it'd be great to share, because we've had a bunch of questions about that.
Yeah, so I will throw out that if folks go, we'll share the slides back out, and I put some pictures of some of the federal agencies doing work on this. So NIST has been doing a lot of really valuable research. They've also created a collaboration space on GitHub where folks are sharing use cases for de-identification tools and sharing open source de-identification tools, which is great. They've also been doing a variety of sort of explainer materials on sort of de-identification 101, and that's actually listed on the recommended readings as well as de-identification for government data sets, both of which are great resources. But also the Commission on Evidence-Based Policymaking had a lot of leading de-identification experts, both from law and policy, on it, and has a really great outline of sort of what these techniques look like going forward. And so really recommend the report from the Commission on Evidence-Based Policymaking. And for folks who really, really want to get in the technical weeds, the Federal Committee on Statistical Methodology is a great resource for thinking through some of these emerging technologies and challenges. The good news is that they are updating the guidance that they've released, I believe back in 2005 or so, in what's called Statistical Paper 22, Statistical Working Paper 22. And that's part of what's the federal data strategy. So is in line to be updated, I think, due August 2020 to provide a more accessible, guide to de-identification tools. So I think those are all great places. I'll also flag that the Article 29 guidance, also on the recommended reading, has a pretty good in-depth technical piece to it. So all of those are great resources.
So we have another question regarding pervasive incentives comment. Doesn't GDPR offer less restrictive requests on portability if you use pseudonymized information? Same for RTBF, RTO, etc.
Yeah, so this is a great example also of the sort of flexibility that pseudonymous information can carry, and not just in US law, but as this person rightly acknowledged in the EU. So the right to be forgotten, and a couple of other kinds of individual rights that can be more flexible. Pseudonymization is also part of the test to determine compatibility for secondary uses, and so and is also considered a privacy by design and privacy by default safeguard. So it can show good faith and try to accomplish a couple of legal goals under that law.
So you mentioned acceptable trade-offs to privacy and utility are a legal question, and you mentioned the reasonable tests. How is risk of harm being measured, or how is it being measured legally? Are there any cases, readings, or research that you'd recommend?
That is a really good question. It's a really hard moving target, unfortunately. So there are a lot of efforts, I know, underway to try to measure privacy attitudes and harms and sort of what the acceptable trade-offs are. There's an interesting effort to quantify that, because you can use that in some ways when you're choosing differential privacy. You set what's called epsilon, and that sort of determines the technological trade-off between privacy and utility. And so trying to reduce that for things like the census is a really interesting, difficult challenge to try to figure out the appropriate trade-off between sort of more accurate population statistics that are the basis for things like congressional representation and federal funding, and significant business development and interests that all rely on access to sort of longitudinal census data against sort of strict privacy requirements captured in the census's legislative mandates. And so there's not a ton there. Sort of thinking through risk of harm, you can come up with it in sort of the mathematical ways. There's also in economics literature trying to have folks measure willingness to pay, willingness to accept, that kind of traditional empirical evaluation. Alexandra Acquisti is a really great researcher on this, has had a lot of really good works that we can try to share with you after, perhaps. And then, of course, there's sort of evolving standing, as a matter of legal, harm, conversations around the standing bar for proving harm in, both the courts and increasingly in FTC consent requirements. So no easy answers there, unfortunately, but I think lots of folks working on this question from a variety of spaces. And if you want to get in touch, please reach out afterwards. I think our email addresses are at the end of the deck that we'll show in a second.
All right, now the final substantive question is quite long, but it's definitely worth asking. So I'll just read it word for word. I was at the ENISA meeting in Berlin this week on pseudonymization, where they made several significant findings, including: 1, hashing is not an effective means of pseudonymization, and certainly anonymization under EU law because it is relatively easily re-identified. 2, differential privacy can never achieve anonymization under EU law. And 3, pseudonymization is rewarded with broader data use under the GDPR, like being exempt from data portability requirements. Do you have any comments on these as the US looks to privacy laws?
Yeah, so I mean, it's a really interesting situation. Very difficult emerging standards between sort of the technological capabilities and sort of legal standards, and trying to figure out what these appropriate trade-offs are. I'll flag, I'm actually going to throw here in the comments for folks as well, a really interesting, let me see if I can do this correctly, a really interesting report that we actually saw come out, I believe, last week from the European Data Protection Supervisor and the Spanish Data Protection Agency around the hash function as a pseudonymization technique. And actually my read on that was a little bit more hopeful than I think Gary experienced in Berlin, which does suggest that there is a very narrow path to anonymization and appropriate pseudonymization. There tends to be a you know, as I was saying earlier, Article 29 and sort of the European regulatory authorities tend to have much more of a, you know, zero risk kind of approach to anonymization. And so, you know, it's a much stronger reliance on technological safeguards and sort of a distrust of contractual promises and things like that. And so thinking through if there's any legal means to re-identify. So, you know, I think these are helpful to see that there is, you know, multiple perspectives in these spaces. We don't have, you know, and probably never will have one clear consensus on these issues. So it's important for folks to stay abreast of, you know, of sort of changes in the technology, changes in the legal standards, and to acknowledge, you know, that it's maybe healthy to have slightly different perspective and slightly different jurisdictions. So. No real guidance on that other than the flag that great to keep track of these conversations. They continue to evolve in a variety of spaces. So.
All right, and we have one final non-substantive question, which is, does this qualify for IAPP CP units? And I'd just like to say no, but we are thinking about it. So thank you for the comment, because it's good for us to know about whether there's interest in this. We'll be putting all of these materials on the landing page of the FPF website. We'll also be providing a comparative written document, which will be released later on in a few weeks. Thank you so much for coming. Please follow us on Facebook and Twitter for future webinars and on other topics related to drafting privacy law. And we encourage open feedback on what you'd like to learn about. Please shoot us an email at fpf.org, and have a great weekend.
Thanks, everyone.